Hi, everybody. Thank you so much for joining us today. I am Michelle Morris from Consolidated Planning Group, and we have a fantastic webinar for you today, full of great information from Jennifer Coulter. She is an attorney, and she's going to be speaking about Medicaid Estate Recovery. I do have a couple of slides to go over, and I'm going to go over the rules of the road for the day, and then I'm going to turn everything over to Jennifer. So first thing I want to let you know is yes, we record every single one of our webinars, and we always put them on our YouTube channel. So later on today, after we're finished presenting, you are going to receive an email that has a link to that recording as well as all the slides attached. So you will receive all of the information we go over today, including our contact information, how to get in touch with Attorney Coulter or with myself and Consolidated Planning Group. The other thing I want to let you know is that because we're in webinar mode, I cannot see or hear the participants. I know you're out there. I hope you're picking up some great tips and tricks and information. If you have any questions or comments, we welcome those. And all you need to do is put them into the chat box, and I will make sure that Jennifer knows what the questions and comments are. So let's get this started. Consolidated Planning Group, a little bit about us before we go forward. We've been around for over 30 years in the financial services industry. We're located just outside of Houston, Texas, but we work all across the United States. So anywhere that you have a friend or family member who might have an individual in their life with any kind of difference, whether it be intellectual or developmental differences, we can still help them. Feel free to share our information with them. We help families plan for the future of their loved ones. We help with investments and securities, life insurance, also understanding the legal and financial nuances around special needs planning. We're members of the Special Needs Planning Academy. We are nationally certified Social Security advisors, and we are chartered special needs consultants. So families come to us to help them with things like planning to protect their family. What if the main breadwinner or the main caregiver is no longer able to do that work? What would happen to your family? Lifetime care planning for your loved one. We talk a lot about transition planning and what happens in these key transition periods in your loved one's life. We can help you sort out ABLE accounts, special needs trust, and other legal and state and federal benefits. And then we're here to advocate for you and to educate you. Truly, our business in a nutshell is that we do everything that any other financial advisor would do, except that we do it through the lens of understanding that your loved one might not be able to be completely independent in their life, and they might need your help for the rest of their life. So we don't plan to the end of just our clients' lives. We plan to the end of their child's life or their loved one's lives. And out of the entire United States, there are fewer than 200 financial planning firms who truly focus on special needs planning the way that we do. That's less than 0.1% of all the financial advisors in America who do this. So when you're working with us, we know that it keeps you awake thinking about who's going to care for your loved one when you can't do it anymore. And to answer that question, a few quick tips we always like to start these webinars with. First of all, start now. It doesn't matter how old your child is, start now. Planning for the future is always easier when you have a longer runway. Think about what's going to happen after high school. There are great vocational options, residential options, and educational options for your loved ones. You want to have time to check into those, check and see if there are wait lists, tour the programs, and see what's going to be a good fit for your family. And our last bit of advice, we always caution families to just be really careful when you're thinking about Who is going to take care of your loved one? A sibling is often an easy answer, but it's not always the right answer. It can create some struggles that maybe you're not foreseeing quite yet. It can create a sense of obligation for that sibling who is taking care of their loved one, but also it can create a sense of resentment from the perspective of your different individual because here's their best friend and their partner in crime who is now trying to be in charge of them, and that can feel a little strange sometimes. So be careful when you're considering having a sibling being the main caregiver of your loved one. That is all. I tried to make it very quick. So we have 12:06. I want Jennifer to be able to have the majority of this time frame. So without any further ado, and we would applaud you if we were in person. So thank you, Jennifer, for being here with us. And I will turn everything over to you.
Thank you so much. Well, I'm glad to be with you guys today, talking about one of my favorite subjects, the Medicaid Estate Recovery Program. I hope after today, not that it will be your favorite subject either, but at least that you will be less afraid of it. Because this is the big, scary boogeyman of all programs out there. This is the program that often gets people saying, no, I won't accept long term care Medicaid benefits. No, I won't accept any kind of Medicaid benefits. We had a client in our office who came in and said he was contemplating suicide rather than getting benefits because he didn't want to lose his home that his child lived in. Um, and of course, our first answer is, well, starting point, let's not do that. That's never a good option. But we had to walk him through this because it's a program with a lot of misconceptions about it. Before we get down into the nitty gritty of it, let me just get out of the way some of the caveats and the legalese junk that I need to tell you guys. It's at the very end of my PowerPoint, but I'm going to start with these things. So, the initial thing to know is, of course, this is not legal advice. Individual situations vary, and you will want to talk to an attorney, planner in your area who can help you through the intricacies of the law and your particular situation. What I'm going to give you is general guidance about the way the program works. And part of that is to say it's really not right to think about a Medicaid estate recovery program. In Texas, we call that MERP. Some states call it MER. I'm going to use the term MERP for it, but your results may vary depending on what state you're in. And that is kind of the starting place for this is your results may vary depending on the state you are in. There is not a single Medicaid estate recovery program. There is a federal Medicaid estate recovery program that is required for each state, and then a lot of latitude for what each state does with it. Um, the other caveat to get out of the way is I'm completely blind. So looking at the PowerPoint and following along with it as we go is not my strongest suit. They have the PowerPoint and we'll send it out to you afterwards. I think we're going to try to follow along with the slides, but honestly, I'm terrible at it. So I'm going to talk and hopefully we'll be able to keep along with the slides. But if not, you'll get a copy of the slides later to keep for your personal review. Okay, let's go ahead and get into it then. So when Medicaid was first set up in the 60s under LBJ, they allowed each state to set up a Medicaid estate recovery program. Sure, if you want to, you can try to recover for the costs that you are paying out for the Medicaid programs. Most states did not do that. Some states did. Oregon did. And they were sort of the model for what to do in the future because it turned out that Medicaid, which is also not a single thing, as most of you guys will know, as you've tried to navigate multiple Medicaid programs. Um, Medicaid is not a single thing either. Medicaid is a series of federally mandated programs administered on a state by state basis. Texas, at the last count that anyone I know ever tried to do, had 109 different programs that all fell under the Medicaid umbrella. And they all have different requirements and they come up with different results for you. So SSI comes with regular Medicaid in Texas. That program is like health insurance, similar to Medicare or Blue Cross Blue Shield or any other insurance you would use. We also have waiver programs that many of you may be familiar with while you are waiting on the incredibly long wait lists for them. Things like CLASS, Star Plus Plus, NDCP. And those waiver programs provide in-home care, but with long wait lists. So it's kind of a lot of different things going on. Well, those programs turned out to be a lot more expensive than the legislature initially anticipated back in the 60s. People needed them more, we needed more programs, more things got added. So in 1993, the federal government, in what we call OBRA 93, OBRA is the Omnibus Budget Reconciliation Act. I think pretty hard about that. We don't usually spell out what it means. Um, OBRA 93, though, said every state must set up a Medicaid estate recovery program. Mandatory now, not permissive,
Mhm.
but mandatory. So each state set about setting up their own program with more or less pleasure about doing it. The federal rules for it are pretty broad. They tell a state, this is what you must do, but here's also what you can do. So they've got both mandatory and permissive elements to the federal program. What each state absolutely has to do is to try to recover from the probate estates of people who start to receive long-term care services after their 55th birthday. There's a bunch of things in there that we need to break down because that definition is laden with some technical terms. So, what's a probate estate? That's going to be our first question, right? A probate estate is all of the are is all of the assets of a person that do not pass via a non-probate distribution. Ugh, that's such a lawyer kind of legal answer to give you. Let me try it in examples because it works better that way. So, if you have a life insurance policy, they will have asked you to designate a beneficiary. Ditto for your retirement plan. If you designated a beneficiary on it, that beneficiary will receive that asset outside of the probate process. It does not pass through the probate estate. Most of our bank accounts will have beneficiary designations, or if you have a co-owner on it, a right of survivorship provision. Although having a co-owner doesn't necessarily mean you have a right of survivorship provision, so something to worth checking out. A lot of people will tell you if you get Medicaid benefits, the state will take your home away. And the reason for that is that most people's homes are probate assets. So I own a home, and when I die, because I am a lawyer who is really good at telling people how to avoid the probate estate problem and not always great about doing it myself. When I die, my home will be owned by the estate of Jennifer Coulter. My husband will have to take my will to the court to probate it. If I didn't have a will, I'm not quite that bad about getting my own planning done. But if I didn't have a will, my husband would have to go to the probate court and tell them, I don't have a will. This is my situation. I'm married. I have no children, blah, blah, blah. And then the court would designate who my heirs at law are. Quick note, if you are in a blended family, if you do not have children, if you have special needs kids, do not have a will. Make sure you have your plan in place. Okay, I'm sorry. That is a side note. I can't help as an estate planning lawyer. In part, I can't help but tell people.
Well,
So
that is so important to tell people and to remind them every time.
yes, unless you are in a first marriage, all kids are kids of the marriage. No one is ever going to be unhealthy, divorced, in a bankruptcy proceeding, in prison. anything like that, you need to get your plan in place. And even if those are your situations, you probably still need your plan in place. Okay, so probate estates. We kind of talked about what that meant, but let's talk about what long-term care services means. So, long-term care services are a particular type of Medicaid benefit. In Texas, there's about 8 of those 109 programs that are long-term care. That's going to be nursing home Medicaid. It's going to be Medicaid that would cover a group home for someone with intellectual disabilities. It's going to be those waiver programs that provide in-home care. It's the PACE program, the program of all-inclusive care for the elderly, the PACE program. There are a bunch of those kinds of programs, but it's pretty limited. SSI's Medicaid, for example, is not a long-term care services program. It does not have to be covered by the Medicaid Estate Recovery Program. So, minimum that states must do, try to recover from the probate estates of people who are receiving long-term care Medicaid programs after age 55. And they can then do other kinds of programs. So we now move from what is mandatory to what is permissive. States can be more aggressive than that. They can trace the Medicaid benefits um, outside of the probate estate. They can get it through beneficiary designations. They can get it um, through right of survivorship provisions, through ladybird deeds and transfer on death deeds. They can do all of that if they want. They can include other programs than the long-term care services programs. They can do it for people who started receiving benefits before age 55. Not every state does. A lot of states were not thrilled about this program. Texas had, all the way back in the 80s, 87? In 87, Texas set up a lien program that is permissible. Uh, they set up a lien program that put liens on people's homes for long-term care services back when it was still a permissive program. It was so deeply unpopular that the legislators went home between legislative sessions, and one of the legislators who voted for it, not even the guy who proposed it, got unelected from his job. The Texas Congress came back in the following session in 89 and said, "We're so sorry. We didn't mean to do that. We're undoing it retroactively. We're taking off all the liens." So when OBRA 93 passed, Texas was unwilling to comply. And they just didn't set up a program. And they didn't set up a program, and they didn't set up a program until eventually the federal government said, "Hey, Texas and you other states who are not complying, we will cut off all of your federal benefits for Medicaid if you don't set up a Medicaid estate recovery program." So in 2005, Texas grudgingly set up a program, and it was such a weenie program. The legislature actually passed this. This is the entirety of the Medicaid Estate Recovery Program statute in Texas. The executive commissioner shall promulgate rules to put Texas in compliance with 42 USC section 1396 PB1. That's it. Everything else about Texas's MERP is something that the executive commissioner of Health and Human Services promulgated rules for, and it meets only the bare minimum requirements of the federal rules. Not every state is that way. So if you are in a state other than Texas, you will want to talk to an elder law attorney, a special needs planner, something like that in your state to ask them what your state's rules are. Are they just meeting the federal minimums, or are they doing the permissive things? Are they going after other programs? Are they looking at SSI benefits? Are they tracing things through non-probate distributions? Are they tracing things through the estates of people for whom there were exemptions during their lifetimes? The federal government does require that states allow for certain exemptions from recovery. The federal exemptions are if there is a surviving spouse, if there is an adult child who is disabled, if there is a child under 21, if there's if there's a hardship, they don't define what hardship means. And so each state is kind of left up to itself to define hardship. If there is a sibling who is a co-owner in the house who was living there for at least, or who was living there during the ownership, if there is a child who provided care for the parent for at least 2 years prior to the parent's placement, and that care prevented the person from being placed. So there's a number of federal exceptions to recovery. Those are mandatory. Every state must have those, but not every state treats them the same. And those are not the only ones that every state has. So think of the federal government as saying, this is the bare minimum of what you must do, but you can be pretty flexible within that. So, for example, Texas says, if you have one of those exemptions, that's it, we're done. We will go away. You provide us a death certificate showing that there's a surviving spouse, and we go away. That's true even if the surviving spouse does not receive the asset. So I had a situation where husband and wife were both placed in a nursing home. Husband and wife both had wills that gave their house to their grandson on their death. Their house was their only asset that would otherwise pass through their probate estate. So grandmother passed. Grandson brought me grandmother's will, explained the situation, brought me the letter from HMS Inc. That's the private company that handles a number of states' Medicaid programs, including Texas and New Mexico. Um, he brings this all to me, and I say, no big. So we provide a copy of the death certificate, we provide a copy of the marriage license, and we provide a copy of grandfather's, um, who is the spouse's driver's license, and we give it all to HMS, and then they go away, even though grandson was receiving the asset because having the surviving spouse was sufficient. Not every state's going to treat it that way. They have to say, well, there's a surviving spouse, and we will not collect right now. But they can say, well, there's a surviving spouse, and we will not collect right now. But when grandfather dies, we're going to go back and come back and try to claim it then.
Mm.
So it very much depends on your state. Um, we can also have other exceptions. Texas has an exception for an adult unmarried child residing in the home who's been residing there for at least 1 year prior to the Medicaid recipient's death. That's not a federally mandated exception. That's an exception that has to do with a court case back when spinster ladies were considered poor dears unable to provide for themselves. And we didn't want to kick them out of their parents' home when their parents died. So we have a court case that basically says, yeah, we want to be setting aside homesteads for the adult unmarried child who stayed with that home and took care of their parents because poor spinster dear has no other options. Fortunately, we've come a long way and we do have other options, but that is an old-fashioned case that has not yet been overturned by the Texas Supreme Court. So fingers crossed, we will get to continue to use it. That has then been built into the Medicaid Estate Recovery Program in Texas. Hardships are also an option. And like I said, hardships depend on the individual state. Texas and New Mexico have generally the same kinds of exceptions for that. Although, again, results may vary. So if you do not live in Texas, you're going to want to get more information about what your particular state does because the federal rules are not entirely clear on this. So a hardship can be for any number of reasons. Hardships in Texas include things like a person who is going to receive a gift from the estate is receiving some kind of means tested benefits that receiving that gift will disqualify them for. So let's say one of the beneficiaries is receiving SLMB. That is a Medicare savings program that covers the costs of copayments and deductibles that Medicare doesn't otherwise cover. It's not going to be someone who traditionally might otherwise meet the SSI definitions. They don't have to be disabled. They don't have to be with income of less than $967 a month, they don't have to have less than $2,000 in total countable resources. The resource limit for that program is higher, more like $9,000 for an individual. But if getting the gift will disqualify that person from that benefit, that's an absolute bar to recovery in Texas, provided you meet the requirements for the hardship. If you could be getting governmental benefits that this gift would disqualify you for, even if you're not, that's a hardship waiver in Texas. If it's a family farm and the farm makes up at least 50% of the income of the family member, that's a hardship waiver. There's a pro rata one that doesn't necessarily give you a full release like the others, but will give you a partial release from the claim for people where the beneficiaries have household income of less than 300% of the federal poverty level. And in Texas, one entitled Other Compelling Reasons. So that's a sort of catch all hardship waiver that says, look, if there's some reason that you shouldn't have recovery, but you don't qualify for one of these other exemptions or waivers, let us know and we'll contemplate it. I will say this, Texas is not completely heartless. They understand that real people's situations don't always fall neatly into those and are willing to contemplate other compelling reasons. So we can always look at those. But the best thing to do if you live in a state where the Medicaid Estate Recovery Program is a probate creditor only is don't have a probate estate. I know previously to this, one of you submitted a question that basically said, what if the special needs trust goes through the probate estate? And the answer is it is potentially subject to recovery if it goes through the probate estate. So try not to make it go through the probate estate. If that's a third party settled special needs trust, something you could amend, um, go ahead and give it a beneficiary on it. Don't have a probate estate. One of the big things that people do to avoid that is, well, we talked about it, right? You're going to put beneficiary designations on life insurance policies and bank accounts. But the big thing that people are concerned about is their homes. You won't hear a lot of people saying, oh no, don't get Medicaid or the state will take your life insurance proceeds. What you hear them saying is, oh no, don't get Medicaid or the state will take your home away. If you live in a state that doesn't put liens on the property and is a probate creditor only, like Texas, New Mexico, a number of other states, then the best thing to do is to use a non probate distribution for that home. The problem is, most of those non-probate distributions are going to make the home either not be exempt for Medicaid purposes or create a transfer penalty. So what a lot of people think is, great, I'll just put the home in a revocable trust and voila, it's going to pass to my beneficiaries, no problem. The problem with that is many states stripped the exemption for Medicaid purposes of the homestead if you put it in a trust. So that's not a great option. What we do instead is something, depending on what state you're in, either a ladybird deed or a transfer on death deed. Ladybird deeds are what we call common law creations. That means I can't point you to a statute saying, here, do this ladybird deed. Here's what it requires. These are the statutes. They are things that come up because there aren't any rules and we try something and then the courts get involved and go, yeah, you can do that. They're kind of fun to develop. I would not want to be the guy who tries it. But since we have developed them, they are a useful thing. Transfer on death deeds are a little different. They are created by statutes. So your state needs to have a statute that says you can do a transfer on death deed. There are some technical differences between them, and choosing one over the other is going to depend on what your state accepts and what your situation is. So in Texas, you could do both. You could do a ladybird deed or you could do a transfer on death deed. In New Mexico, they only do transfer on death deeds. There's no case law saying you couldn't do a ladybird deed, so I guess technically you could, but I wouldn't want to be the guy who does the first one. Um, Good lawyers don't want their clients to be test cases for things because test cases means we have to go in front of a court to decide if this is something we can do or not. But if you have the option of both, you're going to want to talk to somebody individually about what your circumstances require. Because while they do the same things, they do them in slightly different ways and with slightly different requirements. So you'll really want to figure out what works best for you. But what both of those do is essentially put a beneficiary designation on your home. It does it without creating a present interest. So both of those are revocable. You could say, I'm going to give my home to my kid, and then decide, in fact, my kid is kind of a brat. I instead want to give it to my niece. Whatever it is you want. But they are revocable, and that's really important because it means they don't create penalties. They don't trigger transfer penalties because you aren't giving away anything right now. So we use those for homes. We make sure that we have beneficiary designations on all other assets. That can be a little complicated if you've got a vehicle, which is one of the exempt assets for Medicaid purposes. Some states have beneficiary designations for motor vehicles, and some states don't. The other thing you may look at with a home is a joint tenancy with right of survivorship deed. I don't love these as an option unless you already own it that way, say with a spouse. And the reason for that is putting someone on your home as a joint tenant with a right of survivorship creates a present interest, which means you've made a gift to them of generally one half of your house. And remember that in Medicaid, gift is a four-letter word. My law partner always says, regalo es malo. And the reason for that is gifts trigger penalties, and we do not want penalties. We don't want to lose benefits because we've accidentally made a gift by creating a joint tenancy with right of survivorship. So transfer on death deeds or ladybird deeds, those are generally the way to go. That's kind of an overview of how the Medicaid Estate Recovery Program works. One other thing to note about that is that in order to be good creditors, states must do certain things. What they must do depends on the state and the regulations they have set up, but not all states are great at being creditors of the probate estates. So they may fail to meet their notice requirements, in which case we can reject those claims. So even if you have not done good planning, it's not a reason to just give up and pay the state, right? It's a reason to go to an attorney who practices in this area and say, what can we do? Can we do anything? Do we have to pay? Um, Figure out what options are. This is getting, but have historically not creditable. So we have been mostly rejecting claims or using exemptions or hardships. And what is possible, they can be good creditors. They have not been great at it in the past. So it's always worth talking to somebody before you pay. I will tell y'all, how are we doing on time? Do I have time for a quick story before I move on to the next little section?
We're at 12:33. You're doing great.
Excellent. Okay. So I talked to an attorney at a conference after I gave a presentation on Medicaid estate recovery. And he came up and told me he had some clients, sweet little ladies who had been taking care of their disabled sister her whole life. And they got a claim from the Medicaid Estate Recovery Program for like $150,000 for long-term care services that their sister received after she turned 55. Um, and he tried to tell them, oh, he went through everything with them. He said, well, does she have any assets? No. Does she have anything in her probate estate? No. Well, you don't need to pay anything. I mean, there's nothing for them to recover from. But these sweet little ladies said, well, we've been taking care of her. It's our job. And they wrote a check to the state for $150,000,
Hmm.
even though there were no probate assets. The state did not say, hey, wait, that's not right. You don't personally owe this money, right? The state just cashed their check. So the state is not always going to go out of their way to say, is this a valid claim? If you write them a check, they're going to take your check. Now, could they have gone back and said, hey, it turns out we didn't actually owe that and gotten a refund? Probably, at least in Texas. Texas is pretty good about writing refund checks when the claim is not valid or the claim should not have been paid for some reason. And that's pretty important because If you take nothing else from this and you live in Texas, I want you to take this from it. MERP is not a lien program in Texas. MERP is never going to put a lien on your home in Texas. They can in some states, but they don't in Texas. They cannot in Texas. It's not even just that they don't, it's that they can't. But title companies don't always realize how the Medicaid Estate Recovery Program works. I'm talking to them about it. I'm talking to the Title Underwriters Association to try to get them to get that properly. But on occasion, title companies have just written checks to the state on closing instead of writing a check to the executor of the estate or to the heirs. Mostly, we've been able to get refunds for those that were wrongfully paid, but eventually, we're going to end up having to sue a title company over it. Uh, that will get them to change their minds, but hopefully, we can talk them into understanding it before we ever have to end up in a lawsuit. It's not a lien program in Texas. We can't put a lien on the home. I just want everybody to know that. It's not true in every state. There are definitely states that put liens on homes, but Texas isn't going to be one of them. New Mexico, where my practice also practices, is not one of them either. So it's going to be dependent on your state, but do know many states don't put liens on homes ever for any reason. And double check with your state. Okay. There's another aspect that I really want to talk about for you guys, because I've just spent a lot of time telling you MERP can generally be avoided, at least in states where it's a probate creditor only. In states where it's a probate creditor only, it is entirely avoidable with good planning. It's often avoidable without good planning, but it is always avoidable with good planning. So, good, you're done, right? No more need to worry about paying the state. That's not exactly correct either. There are non-MERP recoveries. So let us say that you have a self-settled special needs trust. The terms of that trust say on the death of the beneficiary, the state gets paid back dollar for dollar for all benefits paid out for the benefit of that person. And that is not subject to the Medicaid Estate Recovery Program. That is simply a recovery that is paid because the trust says it is, and the trust says it is because the federal statute that allows us to do self-settled special needs trust says it must. So even if you have a waiver from MERP or a hardship or an exemption to MERP recovery, if there's a self-settled special needs trust, you will still have to pay. There's just not a great way around that. There are some states that say if you have a hardship or an exemption under the Medicaid Estate Recovery Program, we will let you not pay for the special needs trust as well, but not very many. Texas doesn't, New Mexico doesn't. I think California does, but I don't practice in California, so don't cite me on it. There are potential ways to reduce recovery from a special needs trust, but they are not built into the statute and they are not built into the language of your self-settled special needs trust. So Texas, for example, right now is saying, we don't see any way for us to recover real property in a self-settled special needs trust or any way to force a trustee to sell that real property. So if you have real property in your self-settled special needs trust, we will let you have it. Texas right now is saying we will only recover from benefits paid after the date of the establishment of the special needs trust, not for any benefits paid before that date. But they don't have to say either of those things. They can say, I mean, we are the remaindermen, sell the real property and give us the proceeds. They can say, this trust permits us to be paid for all benefits paid out, not just for the ones paid after the date of the establishment of the trust. There's no rule that says they have to do that. They are doing it right now. They are also saying, you know, that other compelling reasons language in your MERP recovery, we'll give you other compelling reasons too. So I recently had a situation where son had quit his job Mom became disabled fairly young, um, and son quit his job managing a restaurant and spent the next 5 years taking care of mom. When she died, there was a special needs trust in place for her. Son didn't have a job, he didn't have an education, and it was really hard after a 5 year break to get back into managing a restaurant. So he wanted to go back to school, but without a job and without an education already, it was hard for him to do that. So we told Health and Human Services, um, TMHP is the agency that actually collects from special needs trusts in Texas. We told TMHP the situation, and they said, we think that's a good use of money. We think it's good for him to go back to school and get an education. That makes him less likely to need government benefits later on. So they gave us a release on that claim. They didn't have to, but they did. So even if you are in a situation where you have an asset like a self-settled special needs trust or a pooled trust, and you have a hardship or you have some kind of situation that may make recovery not reasonable, it's worth reaching out to them. But know that there are kinds of assets that do require recovery, whether or not you have a MERP release. So self-settled special needs trust we've talked about. Pooled trusts have the same kind of recovery provision, with the alternative that if you've placed your money in a pooled trust for self-settled, um, you can, instead of giving it to the state, you can leave it for the nonprofit so that they can defray the costs of maintaining it. Um, the other thing that you might want to look at is for qualified income trusts. These are sometimes called income diversion trusts. There are about 17 states that do these kinds of trusts if your income is above the threshold for long-term care benefits. So the threshold for long-term care benefits is $2,901 a month. If your income exceeds that, then you can't generally receive long-term care benefits. But if any of you have ever priced a nursing facility for a loved one, you can't pay for it on $2,901 a month. So states have to set up a way for you to become eligible. Most states do that the rational way and say if your income is insufficient for the cost of your care and you're spending all your income on your care, yeah, you're income eligible. But Texas, New Mexico, and 15 other states do it differently. Those qualified income trusts or income diversion trusts, you'll sometimes hear them called Miller's trusts, they federally require a payback provision in them as well. So do Medicaid compliant annuities. Those are annuities that people use in certain situations that must name the state as the remainder bin in order to not be a countable resource. Those have a different statute, but they still, by statute, require that the state be named. There is no recovery exceptions as there is with MERP. Now, third party settled special needs trusts do not have to have payback provisions, but I've seen some that do. And the ones that do, the thing is, the terms of the trust control the distributions. So if you have a third party settled trust, just a quick discussion of what that means. A third party trust is one that is created by someone other than the person with the disability, is funded by funds belonging to someone other than the person with the disability. So mostly when we see these, it's mom and dad or grandparents setting up a trust with their own money for the benefit of their child or grandchild with special needs. Those third-party trusts should not have a Medicaid payback provision in them. If they do, then the terms of the trust will control and the state can recover. So make sure if you've got a third-party trust, it doesn't have a payback provision. I got a will from a client who had special needs, and she just wanted me to look at it. It was her dad's will. She said, "This is what he set up. He's still alive. Is this good?" And I looked at it, and it had a Medicaid payback provision. And I went, "Oh no, that's not good." Fortunately, dad was still alive. I called the lawyer who did it, and he might have called me young lady and told me he'd been doing this a long time.
Oh, that's one thing I
So
really hate.
it's not optimal. I wasn't able to talk him into changing it, but I was able to give a letter to the daughter that said, look, your dad's not my client. I can't make him do anything here, but this is what the rules are. This is what it should say. And then she gave the letter to her dad. I believe he updated his will with another lawyer. Um, so make sure that you're keeping an eye on those kinds of things as well. Okay, I think that's everything I really for sure wanted to go through with you. How are we doing on time?
I would love to give you about 10 more minutes if you want to tell us more, if you want
Yay.
some stories. I'm kind of going back and forth through your slides so that people can read them and take a look at them and
Hmm.
see if they've got any questions to put into the chat box. But so far, you've done such a good job of explaining everything that there just aren't very many questions. So if I can give you
Perfect.
another 10 minutes to give more examples and tell us more, that would be great. And I'll
Excellent.
let you know where we're falling.
Okay. So we have been talking mostly then about the federal program, what it requires and what it permits versus state ones. How much does one know? Okay, let me see if I got that question. We just had a question come in and it says, how does one know how much money is involved? Um, I think what you mean there is how do we know how much Medicaid is paying out?
I
And the
think
answer to
so.
that is kind of complicated. You don't, as a general rule, know. Um, we can do some calculations. For example, if you're in a nursing facility, we can tell this is what Medicaid's reimbursement rate is. Here's how much your income is paying. So here's how much Medicaid is paying each day you're in a nursing home. But there are other things that can get covered. So I said before that it must cover the long-term care services, right? But it can also cover other things, including related hospitalizations and prescriptions, which often get covered under Medicaid. There's not really a good way of preemptively knowing how much that will be. Medication amounts vary, hospitalizations happen, and we don't always know what's getting paid for. You can always ask the agency to tell you how much they're paying, but getting an answer from them can be slow and not always is entirely accurate. Many states, many states, um, many states have managed care organizations. So, managed care organizations, let me tell you, only the government would be like, you know what would make the administration of this government program easier? Let's get another level of administration involved. And they outsourced their Medicaid programs to managed care organizations. So, if you're in Texas and you have somebody like Amerigroup, Molina, um, Superior, those are managed care organizations. They administer the Medicaid program. And there's two different ways that they can get paid. They can get paid for the actual services that they provide, or they can get paid a per capita rate, meaning that if they provide fewer services, they just benefit more. If they provide more services, they benefit less. So how they recover depends as well on how they're paying the managed care organizations and on what the state decides to do. Are they going to pay the capitated rate, or are they only going to pay, or are they only going to request recovery for the actual services paid out? Depending on what kind of services you receive, that may be beneficial for one of those payment methods, but you don't get to pick. So it's a little complicated to figure out how much is actually getting paid out. I hate to say that. Okay, I think we have some more questions here, but I missed them.
You want me to tell you the questions or
Yeah,
you got that?
yeah.
Okay,
Can you tell me
so
what the questions are?
sure. Question for the estate. My child is special needs, has Medicaid. So when I pass, can Texas recover against my home that is owned by a revocable trust? Or are we talking about only my child's estate?
Okay, so it's only ever from the Medicaid recipient. That is federal. So only your child, unless you yourself receive long-term care benefits at a later point. But remember, Texas is only recovering if your child starts receiving long-term care services after their 55th birthday. So if your child is receiving SSI benefits, Texas is not going to recover from that. If your child is receiving class benefits, Texas is not going to recover from that unless they switch programs to a different long-term care services program after the age of 55. But it is only ever from the Medicaid recipient's estate, and assets in a revocable trust, remember, are usually going to have a beneficiary designation and not go to your estate, which means even if it were your child's revocable trust, if it has a beneficiary designation, it's not subject to recovery in Texas. Although I do want to point out to the person who asked this question, if your home is currently in a revocable trust in Texas and you later need long-term care services, you've made your home a countable resource. It does count towards your $2,000 resource limit if you're a single person. If you're a married person, it counts towards your incredibly variable resource limit. The better
Okay.
thing to do in Texas is usually to have a ladybird deed or transfer on death deed that names your trust as the beneficiary. That's not always true if you're married. There are sometimes reasons to leave it in a revocable trust, but especially if you're single, it should be ladybird deed to a revocable trust so you continue to own it now. Okay, I hope that's a good
Okay,
answer to that
cool.
question.
That's perfect. So what happens if the disabled adult that has not worked is pushed over the 2901 income threshold because of their parents' benefits, like SSDI or RSDI or disabled
Mhm.
adult child benefits? What if those
Okay,
go above $2,901?
let's disentangle two quick things. The first thing is parents, your benefits, your income, your resources are only going to count where they are deemed. They are only deemed until your child turns 18. So after they turn 18, if it's your benefits, it doesn't matter. You can earn $1 million a month and they won't care. For waiver program benefits, programs like MDCP, what does that stand for? Medically Dependent
Medically,
Children's Program?
yep.
All right. We never use the actual names for things, only the acronyms.
Medically dependent children's program.
There we go. For waiver programs, we don't deem to the parents or from the parents either. So while your child might qualify for NDCP because they have no income or resources, they may not qualify for SSI and regular Medicaid because your income and resources bump them over the limit. Okay, but what if they're under 18 or if they are getting a program like Childhood Disability Benefit, CDB, through the Social Security Administration based on your work history that bump them above that threshold, that's okay. For that threshold, um, for the long-term care services programs in states that don't just say, well, as long as you're spending at least that much on your care, then you're good. For states that don't say that, states like Texas and New Mexico, in that situation, you would create a qualified income trust or income diversion trust. That trust then receives the income source. So let's say you get $3,000 a month in Social Security benefits. That's fine. We take that $3,000 a month, we put it into the qualified income trust, and then the state pretends it doesn't exist for the purposes of making them eligible. States do operate these differently, so it depends on each state. Let me use both Texas and New Mexico because I practice in both states. Well, we practice in both states and they treat them differently. So in Texas, what they would do is say, you have $3,000 a month of income, you put it into the trust, and now it doesn't count against you for eligibility. It will still count for co-payment purposes. New Mexico does it a little differently. They want the excess above the income limit put into the trust. So if you had $3,000, you'd put $99 into the trust. Math in my head. Yes, that's correct math. You put $99 into the trust, they keep it there. The rest of it would count for co-payment purposes. They call that patient liability amount or patient pay amount. And the remaining amount would sit in the trust until eventually it gets paid to the state on the death of the Medicaid recipient. But it's a fixable problem for those long-term care services programs, nursing home Medicaid, and waiver programs. It's not a fixable problem for any other Medicaid program. So you can't have $3,000 a month, pop it into a qualified income trust, and become eligible for SSI. Although, if you have certain income sources like child support, um, other income sources that aren't specifically prohibited, you can put those into a self-settled special needs trust irrevocably and make them not count against them for SSI purposes. Okay,
Definitely.
all right, those all the questions that we have?
Yes, they are. And, we've got 5 minutes left. It's perfect. If anybody else
Okay,
has any questions, now would be a great time. And Jennifer, if you want to, just wrap it up with a summary or I put your email address and your phone number into
perfect.
the chat box for everybody already. And
Wonderful.
yes,
Well, let me say this then. First, it's really important that you guys think about these things now. I loved what you said at the beginning of the program about all of your advice was just fantastic.
oh,
But
thank
doing
you.
your planning ahead of time is vital. You want to be thinking about this now. You want to be thinking about this while you are in good shape and you are able to provide care. You want to know what your plan is. You want to think about the Medicaid Estate Recovery Program. You want to think about what happens if you need long-term care and now you've got your special needs person, your child, your sibling, your spouse, whoever it is, and they are going to need care separately. So it's really important to think about those kinds of things. One cool thing that I have just discovered people aren't using a ton of is sole benefits trusts. And so since we have a couple of minutes, I want to tell you about them because they're
Yeah.
very cool. Sole benefit trusts are trusts that are used by one person who's received or who's applying to receive Medicaid benefits, but who has excess resources. So let's say time goes on, you have a special needs child at home, and now something has happened to you. You've had a stroke, you've developed dementia, something has happened, and you have excess resources. You don't want to have to use all of that money to pay for your own care in a nursing facility or in home so that there's nothing left for your special needs child. A regular third party settled special needs trust does not work in that situation. If you put money into a regular third party settled special needs trust, you're going to trigger a transfer penalty. You could trigger up to 5 years of penalty period, depending on the program and the amount. And that is suboptimal. But a sole benefit trust allows you to put money in trust for the benefit of your child who has a disability or for any person with a disability who's under 65. For your child, it doesn't matter their age. When you can put money into that trust, it does not count against you anymore. It does not create a transfer penalty for you, and it does not count against the person for whom you've established the trust. So they're very cool. Texas and New Mexico both say what makes it a sole benefit trust is that it has at least actuarially sound distributions. Some states say it requires a payback provision. So check on the state you are in and that your child is in, or the person you're going to be benefiting is in. But they can be extremely cool tools in your planning kit to really help. And then one last thing is I'm not trying to cross promote here, but I do want to say having a financial planner is fantastic. Having a financial planner who actually understands your situation is the most important thing. Most financial planners are doing their best job. Um, but when I talk to a lot of them who already represent my clients, and I start talking to them about Medicaid, a lot of what I hear is, I just don't know anything about this. I just had never really thought about it, etc. So getting somebody who really knows your situation and having a whole team there, a financial planner and a special needs or elder law attorney, those kinds of people, as well as care plan managers and care coordinators, having those people on your team can really help make what can be a very stressful situation into something where you can know with some certainty that you have peace of mind because you have a plan and you know it's going to work. Okay.
Thank you so much for that. I
Oh,
have, you know, I try to say it and people say, well, of course you have to say that. So it's always nice to hear those words coming from someone else as well. Jennifer, thank you so much. And thank you to all of the participants who have stayed with us. If you have
yes.
any further questions, please reach out to Jennifer or myself. I've had my Zoom consultation screen up. So I just want to point out that we do offer a completely free consultation here at Consolidated Planning Group. We would be willing to go over any questions that you have, get those answered for you, and then discuss, how we work as a firm and what our fees look like and all of that stuff. But our first goal is truly to answer your questions. So please get your free consultation set up. Jennifer, I have loved having this meeting with you, and I really appreciate everything you've had to say. This has been very, very educational for all of us, I think.
Oh,
So
well, good. I'm
with
so glad to
that,
be helpful.
yes, you've been fantastic. So I'll go ahead and end the meeting. I hope you all have a fantastic week. Go out there and just be awesome, and contact Jennifer or I if you need us. We're here to help. Bye, everybody. Thank you very much. Bye-bye.
Thank you.
Bye, Jennifer.
Bye.